to Sabiran Bibi and then to Kabir Fatima. So once this admission is there, and I have already laid evidence that I have let out to him as a tenant a building portion. So, and he is also paying some amount to me regularly. So this absolutely, once his story of license fails, another thing only that would remain is that he was a tenant under the BBC. That is all. It cannot be any other entry.
No, apart from that, you have to prove that certain premises, certain constructed premises was handed over.
Yeah, that by evidences we have shown. And that
Which is that evidence? Show me which is that evidence that in the year 1962 some constructed premises was given handed over. Which is that evidence? I'm looking for that. Give me one evidence that in the year 1962.
Even otherwise, second, the trial, the appellate court has disbelieved that exhibit. That was in terms of section 15 of that order. No. Why I am relying on that? Because, Your Lordship, there is another judgment which says that there is no particular clause in the counterfoil which is prescribed in BBC Act. BBC Act, Your Lordship, may see the form itself. There is no portion for signature of the tenant. The only counterfoil is the format of the BBC Act very clearly says signature of the landlord. That is all. It does not contain any portion where this tenant is required to sign it as in the counter. That format is there. Your Lordship may see the format itself. That evidence will show.
You show me that evidence that a constructed property was handed over.
And even for counterfoil structure, what my submission is, what are the corroborative evidence
Forget
for
about
that?
counterfoils because your evidence is very, very clear that you stopped making payment of the license fee from a particular
Yes.
date. Right?
Yes.
So therefore, if it was a building, it cannot be said to be license fee. I have no doubt on this. Or you show me something.
If it was a building.
If it was a
If it was a
building,
building.
well, you term it as license fee, you term it as whatever,
Yes.
right?
And
If
second
it is a
point is
building,
Lordship.
in the year 1962,
Yes.
when it was handed over, then that particular
And the suit is
payment,
being filed in 1991
yes,
by so-called granddaughters.
whosoever is filing,
Yes.
whosoever is
And
filing.
secondly, Lordship, the lease was in favor of Kanis Fatima.
That means,
Even the suit filed by a person who is only a power of attorney. These are the basic questions, Lordship, to decide whether
that finding of the learned trial court that they were otherwise entitled to realize the amount is not in dispute. That is not in dispute. There is no such finding that they have nothing to do with it. The finding is that they have not proved the tenancy and you have not proved the license. That is the finding.
even Lordship, if the lease is in favor of some other person, without the permission of the deputy collector, without any decree of the court.
That is not the. Under BBC Act, we are not going to decide the title of it.
Therefore, if the title is not there, Lordship, the BBC Act will not be applicable. First of all, they
That
will
is
come
not
with
your
the title.
case. That is not your case that they do not have any title.
Only till Kanis Fatima, not about these persons, Lordship, who were later on inducted as the owner of the land by Bhattu Bala.
So you will have no relationship with the state and you will enjoy the property.
No, Lordship, the state act at any time because now the lease has expired. Even the lease was renewed in 1985. The state can any time evict me. How can I enjoy the property, Lordship? That is not at all the question. Even the lease has expired. No renewal now, even now. In 2015, Lordship, the entire lease has expired. Now they are also not the owner. Even if accepting that there was some compromise by which the property devolved upon them. Those documents are also not on record.
You just see para 6. ये जरा देखिए इस एविडेंस को, पैरा 6।
मैं लाइसेंसी हूँ, ये बात मुझे 1962 से ही जानकारी, इस बात की जानकारी मुझे 1962 से ही है। जमीन मकान दोनों को मिलाकर है,
मिलाकर लाइसेंस देता है।
मिलाकर मैं लाइसेंस फीस देता था।
यस।
तो जमीन तो हम उसको
जमीन मकान
नहीं पहला फर्स्ट पैराग्राफ में ही है कि जमीन
क्रॉस एग्जामिनेशन, आपका फर्स्ट पैराग्राफ से क्या मतलब?
नहीं क्रॉस एग्जामिनेशन आज के डेट पे है, वो आज के डेट
जमीन मकान दोनों
1962 में उसके ऊपर में हुजूर आया है। 1962 में वेकेंट था, 5,000 रुपया कॉस्ट लगा के अपना खर्च से हमने वहां बनाया। आज के डेट पे जो लाइसेंस फीस हम दे रहे हैं वो जमीन और मकान दोनों को मिला कर दे रहे हैं। व्हाट इज रॉन्ग इन इट? How can I deny in the year 1995 when this cross examination was done? अभी जमीन और मकान जो था उसके हिसाब से हम दे रहे थे, but at the time when I was inducted, it was a vacant land. That is inconsistent with my pleading as well as my first paragraph of my deposition. वो उसमें तो लिखा है कि हम 5,000 रुपए, बाद में भी आया, अपडेट कोर्ट की जजमेंट में भी आया, वो पैसा हमने 5,000 खर्च किया और अभी भी हम लाइसेंस फीस देने को तैयार है। आज तो वही कंस्ट्रक्शन है ही, इनके शेड्यूल में भी है।
कोर्ट का कहाँ फाइंडिंग है कि आपको खाली जमीन है?
नहीं फाइंडिंग नहीं है, 5,000 रुपया हमने खर्च किया वो आया।
फाइंडिंग भी कहाँ आया? तो है ही, आपने जो रिटन स्टेटमेंट
फाइंडिंग तो इस दोनों पॉइंट पे नहीं है।
फाइंडिंग तो नहीं है ना?
फाइंडिंग नहीं है,
Finding
बट
नहीं है।
इट विल बी द एंटायर एविडेंस हैज टू बी रेड इन टोटलिटी, नॉट इन पीस में। शुरू से हम कह रहे हैं, हमारा प्लीडिंग में वही है, एज ऑन डेट लॉर्डशिप इट वाज कंस्ट्रक्शन था, हमने बनाया है, उसको हम एंजॉय कर रहे हैं। आज भी वहां पे कोयला गोडाउन एक टिन शेड लगा हुआ है। पैराग्राफ 1 में पूरा एलैबोरेटली डिटेल्ड लिखा हुआ
है। आपको कोई पॉसिबल प्रूफ तो ये एविडेंस इन चीफ आप बिना क्रॉस एग्जामिनेशन के पढ़ेंगे तो क्या ही?
आप जो भी किराया दे रहे हैं वो जमीन और शेड को मिलाकर दे रहे हैं, तो वही लिखा है कि हाँ उसी को मिलाकर दे रहे हैं।
ऐसा नहीं है,
उसमें ये डिटेल नहीं कहेगा हुजूर कि हम उस समय जब लिए थे उस समय खाली था, 10 शेड अभी मिलाए हैं, तो तुरंत वहां पे रोक दिया जाता है। जितना पूछा जा रहा है उतना ही का जवाब दीजिए, क्योंकि ऑलरेडी द थिंग्स हैव कम इन द रिकॉर्ड। इट इज नॉट माय बियॉन्ड माय प्लीडिंग। दिस इज हाउ द क्रॉस एग्जामिनेशन गोस। आप बिल्कुल मिलाकर दे रहे हैं, वो बोलेगा ही। और अपने प्लीडिंग में कभी इनके नहीं लिखा हुआ है कि टिन शेड बना के इनको हम दिए उस समय जब 1962 में जब रेंट दिया गया था। इट इज नॉट इन देयर प्लीडिंग आल्सो।
Samiran BP was the
original leaseholder। उसके बाद कनीज फातिमा के नाम से हुआ 85। अच्छा, moreover lordship, very important thing, when this suit was going on, the Kaniz Fatima and her husband both were alive. They could have very easily come to the court and said कि हाँ हमारा बंटवारा हो गया या इनके नाम से हम लोग कर दिए हैं, अब ये लोग जमीन के मालिक हैं और हमारे लाइसेंस नहीं या रेंटर थे या लाइसेंसी थे, जो भी जो कहना चाहते थे वो आके कह सकते थे। एंड इन रिलेशन दे आर दी शी इज द मदर एंड फादर। मौसा सर डिवॉल्व भी नहीं हो।
अब ये पैरा 6 and 7 है एविडेंस आपके पास?
Clear Lordship, the entire property is not devolved to the state.
One paragraph is
इसको पूरा पढ़िए तो 2 मिनट में
कौन सा कुछ करें? 5 6
6
7
and दोनों क्रॉस एग्जामिनेशन पूरा
मैं लाइसेंसी हूँ, यह बात मुझे 1962 से ही जानकारी है। इसकी जानकारी इसमें मकान दोनों को मिलाकर, जमीन मकान दोनों को मिलाकर मैं लाइसेंस फीस देता था। लाइसेंस मिलाकर मैं फीस देता था यहाँ पे। लाइसेंस फीस देता था। बातचीत कर समीरन बीबी मेरी कुछ नहीं लगती। समीरन बीबी मेरे अंश को मकान है, सबकी मालिक है। समीरन बीबी और हाँ, सबकी मालिक अच्छा अमीर महिला थी। समीरन बीबी आगे बढ़ो हमने लाइसेंस पर मिली
पढ़िए इसको ध्यान से और इसके इम्प्लीकेशन
प्रति परीक्षण।
मैं
मैं लाइसेंसी हूँ, यह बात मुझे शुरू से 1962 से ही जानकारी है। जमीन मकान दोनों को मिलाकर मैं लाइसेंस भी देता था। समीरन बीबी को मैं बातचीत कर अपने जमीन दिया था। समीरन बीबी मुझे कुछ नहीं कहती थी। समीरन बीबी मेरे अंश को लेकर अपने यहाँ जितना दुकान मकान है सब की मालिक है। समीरन बीबी
अमीर
महिला थी। समीरन बीबी हमसे लाइसेंस पर जमीन लाइसेंस पर
पढ़ी लिखी
हमको लगा हम पढ़ रहे हैं।
कोई लिखा पढ़ी नहीं।
जानता हूँ
हाँ
परमिशन देकर मुझे मकान बनाने
लेकर मुझे मकान बनाने की मकान का मालिकाना हक समीरन बीबी का ही रहा। लॉर्डशिप अब आ गया, क्लियर आ गया मुझे। permission, she took the permission and she allowed me to construct whatever I constructed. उनका मालिकाना हक रहा. पालिका में टैक्स नहीं. सबीरन बीबी ही इस मकान का नगर पालिका टैक्स देती है. मैंने कोई टैक्स नहीं दिया. पैराग्राफ 7 में उसे आगे
बताइए आपको टेंडेंसी कैसे एस्टैब्लिश करना
दीजिए.
Which is a-
As your lordship pointed out, as your lordship read that, once he says that, let us assume that initial lease was of a vacant, or whatever license was of a vacant land, he constructs. All these facts, let us assume that it is.
correct.
But once he pays some amount combined for the use of the building as well as land, then he is a tenant under the building. So how can a fact that initially he was let out a vacant portion of land?
If a person is let out a vacant portion of land and he constructs in a building on that, then his status changes from licensee to
No,
a tenant.
he constructs and then he pays rent for the building
And
as well as the land.
show me something.
That is the judgment which I am just trying to serve. Your lordship may give me a few minutes. In the meantime, they
You see now
that is there.
now the evidence is very clear that you claimed that in the year 1962 you took the property from her land. Let's assume and then you have constructed some portion on that. And then thereafter you say that the ownership of the land belongs to the owner of the land. The ownership of the building also belongs to the owner. And then you continue to pay the
whatever fees.
some rent fees, whatever license fee or rent. Does your status, do you acquire the status of a tenant?
Tenant as per TP Act, not as per BBC Act. That is my question.
Tenant as per TP Act is for the vacant land.
For the vacant land, but if I have constructed in a vacant land, my status will not change from TP Act, tenant of a TP Act, to a tenant of a BBC Act. इस पे भी हम लोग रिसर्च करते थे.
अब रिसर्च करके पूरा दिन सुनिए, आपको कोई रिसर्च नहीं करेंगे तो हम भी
नहीं वो है वही है.
आप खोजिए
हाँ ये खोज रहे हैं.
find it out. You also find it out. अगर इस पे जजमेंट है तो बात
एक चीज I must be very clear. If originally it was let out a vacant land and the rent is being paid for the vacant land,
and
then that would be different. But once he says that he is paying rent, as per his own case, it is my case that I have let out a building. But as per his own case, once he says that he paid some amount for the use of building as well as land, then that absolutely converts his tenancy into a building. He becomes a tenant under the rent control.
And so far as payment of amount is concerned, that is an admitted fact.
Yes.
That is an admitted fact.
Admitted fact.
And non-payment from a particular cut-off date
That
is also an
admitted.
admitted fact.
Absolutely.
To the original owner, not to this person.
Whosoever. To the original owner,
And-
whosoever be the person.
That establishes
These are not the
that by
owners, Lordship.
Kanish
That is,
Fatima,
Lordship had rightly pointed out initially. These are not the owners. कहाँ से ownership आया?
by
नहीं,
Kanish
ये
Fatima,
तो issue ही नहीं है ना. You see the judgment. Where have you disputed a title? And
We
where
have
is
said
it?
we are
You must have said
we are the
that there-
licensee of
but-
Kanish Fatima, not
but
of
there
these
is-
Maktubalam.
There is no finding to that effect. There is no finding to that
Lordship,
effect.
for deciding the relationship of landlord and tenant, at least Lordship will have to come to a finding
ऐसा
whether they are the
यहाँ
owner or not.
trial थोड़ी करेंगे.
Any person Lordship without any document coming to a court that I am the owner of the land and I am denying my relationship with that person vis-a-vis. I am just accepting my tenancy right or my licensee right with Kanis Fatima, not with the subsequent persons.
So after death of Kanis Fatima.
Yes.
the
Not death, not death. Death कहाँ हुआ है?
After partition.
After partition.
Partition का कहाँ डिग्री है?
This license, this particular document that fresh this settlement was there with Kanis Fatima has been exhibited.
Yes, it has been exhibited. 1985 document.
उस पे कोई dispute ही नहीं है. Kanis Fatima is the owner, but not these three ladies. वो उनका तो relation ही उससे नहीं है. And they are saying they have acquired their right, title and interest by way of a compromise degree. Where is
Exhibit
that
8
degree?
is degrees.
Where is that degree? Exhibit 8 is admitted. How these persons are claiming their ownership vis-a-vis Exhibit 8?
So far as the compromise etc. is concerned, there is a finding that there was a compromise.
No. Compromise तो दूसरे सूट में हुआ है. Eviction सूट में हुआ
हाँ,
है.
eviction suit.
No.
Compromise.
In this partition suit also,
कहाँ है वो
Which
कागज?
is that exhibit?
compromise petition is exhibit 1. It bears the signature of Kanis Fatima.
अरे compromise petition in a suit of a partition suit without any degree. No judgment has been passed. No degree has been passed. Only a document is being brought before the court. Exhibit 9 and 10 Lordship was of a different tenant. उसका कॉम्प्रोमाइज एग्जिबिट हुआ है. वो आके बोला है कि हम पहले टेनेंट थे, अब हम कॉम्प्रोमाइज करके इनके नाम पे छोड़ दे रहे हैं. इज इट बाइंडिंग अपॉन मी?
नहीं वो बाइंडिंग.
Whether by that Lordship they will become the owner of the land? Ownership का तो सिर्फ कॉम्प्रोमाइज डिग्री होना चाहिए था. Chain of documents is not clear. Chain of title is not clear.
This compromise was also denied in the written statement.
So, Your Ladyship, but they have accepted this fact that Kanis Fatima refused to accept the license fee, but they have not stated the reason. Why did she refuse to accept
She
the license
was alive. She would have examined by you. अगर आपको दी थी तो कोर्ट में क्यों नहीं आके एग्जामिन कराया?
सगी बहन, own sister. You have not examined.
fee? Kanis Fatima was not accepted.
And there is this fresh lease in her favor.
1985.
1980.
Please.
So how do you establish the relationship of landlord and tenant through this power of attorney holder? Is there anything to show that the rent was ever paid to the power of attorney holder? Is there anything? Any oral evidence also?
There are rent receipts.
No, rent receipts have been disbelieved.
Only for the reason that it does not bear the signature of.
That's whatever be the reason. We are not on perversity. We are not on perversity. And as per this, you paid rent till when? Till when did he pay rent?
ये भी बात है. हम till 1990 90 तक दिए हैं. 91
किसको?
कनीज फातिमा लाइसेंस फीस दिए हैं. फीस till 90.
जो भी लाइसेंस भी हो.
और ये क्लेम कर रहे हैं 89 दिसंबर से अप्रैल 90 तक का, और 90 तक का ऑलरेडी हम दे चुके थे. Therefore, this is a created document, and it is my admission.
But they have not got anything on.
अब फिर हम नहीं लाए.
Yes.
हम उनको नहीं बताया, हम लाइसेंस फीस नहीं दिए, हम कुछ नहीं दिए, आप सब कुछ ले आए. Even the Kanis Fatima who was alive was not examined by you. adverse inference will be drawn against this.
And the change of status of landlord is also to be intimated, no?
Yes. No adornment. We are accepting 90 तक दिए हैं, 89 से लेकर 9 अप्रैल 4 तक का कैसे देंगे? And therefore it was disbelieved rightly by the appellate court. 91 से शो करके उसे they were in hurry to file a suit.
और नोटिस भी उनको मिला नहीं है. इनको रेंट देने का कोई भी एविडेंस है क्या? नहीं है ना, ओरल भी.
No independent witness have been examined.
इंडिपेंडेंस से छोटी ना, इंडिपेंडेंट का आंसर. कोई तो एविडेंस है. Is it your case that they paid rent to you till a particular date? और ये पावर ऑफ अटॉर्नी कौन सी डेट को?
Exhibit 3 is the power.
Date. And who gave the power of attorney?
31/19 30/1/1980
1980.
30/1/1980 and the executants are the three daughters of Sora Khatun.
And thereafter there is a lease with Kanis.
Lease with Kanis 1980.
Thereafter
85 का lease.
85 Kanis. तो उस समय का power of attorney, and he says that he was looking after the property of Samiran Bibi. The entire property जो भी था Samiran Bibi का. Samiran Bibi died in 1968 and he was looking after the property of Samiran Bibi. And in the year 1980,
He got the power from three ladies.
he got the power from three ladies, right? But the property was there
Transferred
was a lease deed in favor of Kanis
in 85.
in 1985.
Yes.
Then there was a partition suit,
Partition.
and then this property was allocated to these
Three ladies.
these three sisters. And then there is no fresh power of attorney to represent these three sisters pursuant to any compromise or to collect rent or something like that. ऐसा कुछ भी नहीं है that he will be collecting rent on their behalf. ऐसा तो नहीं है, right? Now the point is that even if there is a transfer of property, firstly it is not a transfer. Anyways, let us assume for a moment that in partition this property was allocated to them. Then also there has to be something more to that, and the partition duty has not been exhibited. You have only exhibited the
Compromise petition.
compromise petition. That compromise itself is disputed. So compromise will be proved only by virtue of the decree. Without a decree, how a compromise can be
One
proved?
more point, Lordship. The power was of 1980. How the subsequent property, if at all devolved to them, how the
Shall
interest
devolve.
of that property will go to that power of attorney holder.
अब सुनिए जज, अब बैठ जाइए, दूसरा कोर्ट पे जाना है, कुछ और बोलना है आपको बताइए. आई एम नॉट विथ यू. इफ यू हैव टू से एनीथिंग मोर, आई एम नॉट विथ यू. Tenancy has not been proved at all.
But we are
Tenancy with these three ladies. Not only tenancy with these three ladies does not happen. आपको मिला जजमेंट?
One night.
नहीं. ठीक है.
My last submission. That civil cases, as your Lordship, are not required to say that preponderance of evidences Now here the evidence is that they are claiming themselves to be, they are not claiming themselves to be the owners of the property. They are themselves saying that there was Sabiran Bibi who had given the property to them, or that they were giving, periodically they were paying some amount to Sabiran Bibi and thereafter to Kanish Fatima. And it is their own statement which are not required to prove. There is own statement that Kanish Fatima refused to accept license fee after 1990. So, based on that, because there was already evidence on our part that Sabiran Bibi is none other than the nani of all these three girls, because Sabiran Bibi had two daughters, and they are the Kanish Fatima is own Masi of these three. So,
Where is the pleading in connection with this lease to Kanis? Who has taken this
these,
lease to Kanis
In the print,
in the plate?
yes.
we have also executed the lease.
True that the Kanis was the owner of it.
But Kanis herself denies acceptance of rent, and that cannot be overlooked. And that is the statement or admission of the defendant himself. And now it would be a matter between me and Kanis, because other facts which were accepted by the trial court have been disbelieved by the appellate court on some other reasons. The appellate court also says that the defendants, they have failed to prove their story of license.
अच्छा देखते हैं थोड़ा सा दिखाना शुरू.
ठीक.
Heard the
Do
learned,
whatever is needed.
heard the learned counsels appearing on behalf of the parties. The appeal has been filed against the judgment dated 2/7/2003, within bracket decree signed on 9/7/2003, bracket close, passed by learned second additional district judge Chaibasa in eviction appeal number 2 of 1998, whereby the learned first appellate court has allowed the appeal preferred by the respondent. The title suit judgment is dated 9/2/1998, passed by learned subject Roman to Jaibasa in eviction suit number 4 of 1991, whereby the learned subject Roman to Jaibasa allowed the suit in favor of the plaintiff. The suit was filed seeking eviction under the provisions of BBC Act on account of default in payment of rent. The appeal was admitted by this court by the order dated 6/3/2006 on the following substantial question of law. Quote currently. During the course of hearing, the learned counsel for the respondent has submitted that there is an error in substantial question of law number 2, and since it was a defendant who was claiming to be a licensee and not the plaintiff. The plaintiff claims to be the landlord of the property. Correct? Yes, I am. Accordingly, with the consent of the learned counsel for the parties, the substantial question of law is slightly modified by correcting the error to be read as follows. Quote currently, whether the learned lower appellate court has committed an error in holding that the defendant could not substantiate its case that the defendant is a licensee or not. the specific case of the plaintiff was that the plaintiff was representing the during the course of argument, it is not in dispute that the property is a Khasnaik property. Khasnaik lease property executed by government.
Leasehold property of Khas.
Leasehold property of Khasnaik executed by
By the
government
government.
in favor of Samiran Bibi, who died sometimes in the year 1968. She had two daughters, namely Sohra and Kaniz. And Sohra had three daughters, namely Saleha, Saneha, Ashrafun, Ashrafun, and Khairun, Khairun. All daughters of late Mansoor Ali, and the plaintiff was the power of attorney of all the three daughters.
इसमें ज़रूर एक और बात बोलेंगे. इस सलेहा का दो बच्चे और थे. That has come in our pleading.
इससे क्या मतलब?
हाँ, मतलब है उसको. क्योंकि अगर पार्टीशन होगा तो सबका सिग्नेचर रहेगा. सब्सिक्वेंटली हम बात करें.
इतना नहीं, आप तो
खाली
सुनिए ना,
बता दें.
सुबह 10:30 बजे से सुन रहे हैं, प्लीज नहीं.
नहीं वो हमारे WS में चूंकि हम उसको पढ़े नहीं इसलिए हम बता दे रहे हैं.
ऐसे नहीं कर सकते. जितना आप लोग बताए हैं उतना ही लिखिए.
ये है वो WS में
है तो बहुत चीज रिकॉर्ड में.
That was important. यहाँ लिखा है इसलिए बता रहे हैं.
It was the case of the plaintiff that Town Khasnaik holding number 939, portion of Khasnaik plot number 1864 corresponding to municipal holding number 2 of 13 was situated in ward number 13 which belonged to Samiran Bibi. And Samiran Bibi died leaving behind her two daughters, Sohra and Kaniz. It was also the case that a partition suit was filed with respect to the property of Samiran Bibi, which was registered as title with the partition suit number 31 of 1987, which ended in a compromise between the parties on 27/11/1989. The compromise was signed by the plaintiff being the power of attorney of three daughters of Sohra, and the suit property was allocated to the three daughters, and accordingly decree was drawn. The case of the plaintiff was that in the partition suit, the properties which were allocated to them was vacant land with 2 rooms and 1 gummiti and 1 covered garage with tin shed, and 3 tenants were inducted, including the present defendant and the other 2 were Narayan Sao and Kutubuddin, who were in possession of the suit property as tenant under Kanis Fatima. It was the further case that after partition, all the tenants agreed to atone the 3 daughters of Sohra as landlord with respect to the house and the premises in their occupation, and the plaintiff as an attorney started realizing rent from all the tenants, including the present defendant. The present defendant was in occupation of house premises consisting of one tin shed room which was being used as garage and coal depot. It was the case of the plaintiff that the defendant continued as a tenant on monthly rent of ₹50. तो याद ही नहीं।
also लगता है so engrossed in the matter.
आप लोग एक काम करेंगे, हम आर्गुमेंट्स कंक्लूड कर देते हैं। आपने जो भी अपना सबमिशन किया है 1 पेज, 2 पेज में
हम तो
लिखो
बड़ा
मैक्सिमम।
शॉर्ट
छोटा शॉर्ट अभी हमको फ्रेश है, हम दिखाएंगे।
ऐसे यूजुअल बनाए आपको टाइप करके अच्छा से.
हाँ, टाइप करके हमको, आप भी हमको टाइप कर। आपने अभी जो मिस्टर राहुल गुप्ता ने बताया था ना, वो that he said that she purposely stopped accepting rent, so this conduct should be considered. वो एक है आपका important point जो आपने उन्होंने बताया था, उसको भी include करके आप हम हियरिंग कंक्लूड कर दें, कल तक दे देंगे। हाँ ठीक है, इतना छोटा सा बनाना है।
वो मिल गया वो जजमेंट, लेकिन हम कह रहे हैं 2007 PLJR है, लेकिन पहले का भी है। It says that in case where originally the premises was vacant land and subsequently the tenant makes construction and pays rent for the entire
अच्छा, एक
premises, the said
एक
premises.
the court proceeding is over, the matter has remained inconclusive, post this case for further hearing। कल ये जजमेंट आप लोग एक्सचेंज कर लेंगे प्लीज। ये जजमेंट वो जो जजमेंट है ना, अगर बिल्डिंग लेकर कंस्ट्रक्शन
ये तो ठीक है इस पॉइंट पे, लेकिन अभी तो कंटिन्यूअस ऑफ द चेन ऑफ ओनरशिप इज आल्सो रिक्वायर्ड टू
we'll see that